Hello, my name's David Bruce. So I wanted to talk to you today about copyright, which is one of the few subjects that makes me absolutely furious. I certainly have political views about things, but on the whole, things are usually so complicated and confusing that in a lot of cases I can see two sides to an argument. But when it comes to copyright, I can see absolutely no valid argument for the way things are. So anyone who is any kind of artist knows that creativity doesn't exist in a vacuum. You're always taking other people's ideas, getting inspired by them, messing around with them, twisting them, putting them into new contexts, remixing them. I guess anyone who isn't creative doesn't really realise how much this is part of the process. And in today's world, I think we're made to feel almost embarrassed and ashamed when we do this. As copyright expert Kembry MacLeod said, the law itself assumes a romantic notion of authorship. The lone individual genius toiling away until a burst of creativity creates a truly original work unlike anything else that previously existed. But we know that in the world of music, you can't really create a new song without referring to an old song in some way. Culture is collaborative. Walt Disney was actually a perfect example of how remixing culture works best, which is ironic because the Disney Corporation are now one of the main villains in the world of copyright law. Mickey Mouse's first outing, the film Steamboat Willie, was a parody of Buster Keaton's Steamboat Bill, and Keaton's film was itself based on a popular song, Steamboat Bill.
Down the Mississippi steamed the Whippoor Will, commanded by that pilot, Mr. Steamboat Bill.
Many of the early classic Disney films were based on existing stories such as the Grimm fairy tales, reimagining them completely, often turning the dark and menacing originals into lighter, more uplifting tales that the world fell in love with. But today it's the Disney Corporation who are leading the way in lobbying to perpetually extend copyright protection. And what makes this particularly hard to take is that had this been enforced in the early 20th century, Disney's early successes just wouldn't have been possible.
Down the Mississippi steamed the Whippoor Will, commanded by that pilot, Mr. Steamboat Bill.
Culture is collaborative, so nothing is created in a vacuum. The same is true in the world of innovation and technology, patent law. If you come up with an invention, you generally have 20 years to make a profit from your invention. 20 years, why is the time frame set to that? Well, it's because people feel that 20 years gives you a good amount of time to make some profit, but not so much that you actually stifle further innovation. You invent something really useful, 20 years gives you time to develop and profit from your invention, but then after that others can enter the market, use your invention and compete with you, driving innovation forward. So you might argue over the precise lengths, but overall things have been roughly that way in the technology world for quite some time, and it seems to work pretty well. So now let's compare that to what happens when it comes to the copyright world. As things currently stand, in Europe the rights to the work remain in place until 70 years after the death of the author. So in the case of some of my favourite works, say early works of Stravinsky, they were written in the 1910s, already over 100 years ago. Well, Stravinsky only died in 1971, so it's still another 22 years until 2041 before any of those works will go out of copyright in Europe, over 130 years after they were created. In fact, in 2011, an amendment to the European Copyright Directive changed the rules so that if there was more than one artist involved, for example, if a song had a lyricist as well as a composer, then it's 70 years after the death of the last surviving creator before the rights are released. This was highly convenient in particular to the Gershwin estate, one of the most profitable estates in music, because of course many of George Gershwin's most famous songs were written with his brother Ira Gershwin as lyricist. Now George died in 1937, so in 2008 his works did, I believe, come out of copyright. But Ira only died in, wait for it, 1983. So when the law changed, that meant all those works, Embraceable You, Fascinating Rhythm, Let's Call the Whole Thing Off, they all went back into copyright, and they won't be back out again until 2053. In America, the law is based on the number of years since the first publication or creation, and as this graph shows, it's been subject to numerous extensions and fiddles over the years, so that now a lot of works remain in copyright for over 90 or even 120 years after their creation. As a general rule of thumb, only with works written before 1923 can you be pretty sure something is out of copyright. Now, I'm not a lawyer, of course, so all of this is only my understanding. So who benefits from this setup? Well, there's only really one beneficiary, and that's the estates of the rights to these works. And it can be big business. The Gershwin estate makes several $1 million a year, and several major publishers have pretty much survived off the income of one or two big hits from 100 years ago, and in some cases have gone into sharp decline once that copyright finally expired. Typically, traditional publishers sign a contract with the composer to own their copyright outright. So most composers who are with a publisher, as soon as they finish a piece, it's no longer theirs. It is owned by the publisher, and they will have made an agreement so that they will get maybe 50% of the performance royalties for the work during their lifetime. But once they die, and for the next 70 years after that, all the money will go to the publisher. The only justification for a copyright that continues after death is the idea that copyright is like property and should be passed on from one heir to the next. But that ignores several common-sense counter-arguments, all of which point out some fairly tragic results of the current setup, and all of which distinguish this kind of intellectual property from ordinary property. Firstly, while those blockbuster hits do fine, lesser-known works remain prohibitively expensive for groups to play. They remain under the lock and key of the publisher, and buying or hiring parts can be hugely expensive. How on earth is a musical culture supposed to remain vibrant, active, and alive? You know, you're a college band, let's say you could play a radical modern piece like Stravinsky, yes, I'm being sarcastic, and buy the score and parts for, say, $200, which is what they often cost. Or you could play Mozart and print off the parts for free from a website. Now, your entire budget is $50 you borrowed from your mum, so which option are you going to choose? In fact, when I shared a draft of the script for this video with my patrons on Patreon, Chris Farrell came back with a very similar story. Chris is in an amateur clarinet quartet, and he's stuck in two respects. There are very few public domain pieces available to print out on the one hand, and on the other, if he wants to arrange anything himself, he's in legally dubious territory if he tries his hand at anything less than 100 years old. So in both respects, copyright causes the dissemination of newer works to be much more difficult. Now, of course, copyright law wasn't always this way. The 1909 Copyright Act in the US gave works 28 years of protection, so similar to patent laws. And there was an option for a one-time renewal for a further 28 years if the owner went to the trouble of renewing it. That particular aspect is so important because what makes me angry more than anything, and this is tragedy number 2, is that the law as it currently stands automatically applies to all works of art. Now, for the vast majority, probably 90% of works or more, a few years after their creation, nobody really cares about them anymore. The original copyright owner has moved on and doesn't care, but those works are still not accessible to us without fear of legal action. In many cases, they're locked away in a publisher's basement, never seeing the light of day. Or in other cases, nobody even knows who owns the copyright. These are known as orphan works, so there's literally no way you can know for sure if you're legally able to use it. And the third tragedy is probably the most important, and it comes back to the fact of creativity. Excessive copyright prevents innovation, and that's true whatever the art form. In his book Creative License, The Law and Culture of Digital Sampling, Kembury MacLeod talks about how the golden age of sampling was between 1987 and 1992. Record companies still thought hip-hop was a fad, so they didn't pay attention to what these artists were doing. This gave hip-hop artists the creative elbow room to run wild with this new technology and make music in whatever way they wanted without worrying about a lawyer looking over their shoulder. And then 2 lawsuits in the early 90s scared the entire industry enough to mean that from then on they would become far more cautious and only allow artists to use samples if they could clear the rights. But finding rights holders and clearing samples can be incredibly expensive, time-consuming, or even impossible. And MacLeod suggests that 2 influential hip-hop releases, the Beastie Boys' Paul's Boutique and Public Enemy's Fear of a Black Planet, would be financially and bureaucratically impossible to release today due to their heavy sampling. To realise how messed up this whole thing is, it's painful to realise that samples could potentially fall under the doctrine of fair use, which holds that transformative use of material is acceptable. It's hard to see how using a fragment of an old song within a hip-hop beat is not transformative. But in the US, the expense of taking a test case all the way to the Supreme Court is so great that no one's ever done so. Most have settled out of court before a ruling could be made. But if anything, what we're seeing in the US in particular is things moving in an even more worrying direction. The Blurred Lines case, where the jury found that Pharrell Williams and Robin Thicke's Blurred Lines had copied Marvin Gaye's Got to Give It Up, seems very, very close to insisting that a feel for a piece of music can be copyrighted. And if that really did become the case, then basically pop music's doomed. Now, I realise that the use of samples and the problems of classical music publishing are 2 somewhat different issues, but they're also part of the same issue we face with the pendulum swinging too far in favour of the rights holders. The simple fact is, just like in patent law, copyright law ought to be a balance between the whole point of copyright, which is to encourage and incentivise artists, knowing that they'll be able to benefit financially from their work, but balancing that with the need for society and future artists to have access to these works. It's not like there aren't solutions. MacLeod, for example, advocates a compulsory license system, which means that Congress could fix the level of compensation that rights holders receive for sampling uses. So there'd be no need to hire lawyers and negotiate each time, but the rights holders would still get some compensation. That's the pendulum swinging back into balance. And when it comes to the works of classical composers, I'm not at all arguing that composers, while they're alive, shouldn't be able to reap the rewards of their works. They should. Something like the original 1909 approach seems about right. Give an automatic period of, say, 30 years, and if the work happens to be really successful, then you could extend it for another 30. To be honest, I would settle for an optional extension until the death of the author. But what I just think is outright wrong is for it to extend beyond death. Once the author's dead, I firmly believe all of these older works should be part of our cultural heritage. They should be ours as a society to use as we want. This is how things worked for Disney and Gershwin, and to me, the degree to which this has happened really does represent a theft of what should rightfully belong to all of us, and it makes me really cross. One further solution is for artists who aren't concerned with financially profiting from their work, and that is the Creative Commons license, which was established by Lawrence Lessig and others. Creative Commons offers you various ways of granting a license for others to use your work in various ways. You can offer it freely for non-commercial use, or reuse with attribution, or just completely open to reuse in any form. It's the equivalent of the open source movement in software development, which itself has successfully shown how a less controlled and less protected environment can lead to huge benefits and successes both for individuals and society as a whole. Creative Commons is a valuable addition which offers both an alternative to artists, but also helps highlight the need for different options. Lessig himself has been a strong proponent of copyright reform and an advocate for a strong public domain, and I highly recommend his book Free Culture, as well as Common as Air by Hyde, if you want to look into this topic more. I should say for full disclosure that I have a stake in both sides of this argument because I am of course a composer, and having a right to earn £3.37 in royalties from a performance of one of my piano pieces is one that I treasure. And on the other side, as many of you know, I run the 8notes.com website, which offers arrangements of out-of-copyright public domain pieces from traditional and classical music. And I can certainly admit that taking the copyright laws back to 1900 would certainly benefit me a lot there. But to me, this isn't about money, it's about artistic freedom and the need to understand the way art and culture moves forward. To give just two further examples, most of the works by one of the 20th century's most innovative artists, Andy Warhol, would be impossible in today's copyright climate. And in music, to see how even first-rank artists remix old work, look at John Adams' work Absolute Jest, which takes clips from Beethoven's string quartets and moulds them into what I think is one of his best pieces. You could easily imagine that Adams might have fancied doing something like this with, say, Stravinsky instead, but of course it probably didn't even cross his mind. We've all set ourselves by default to assume that any music that has any sense of modernity to it is not something we can play with like this. So a living, thriving, developing, self-referential culture has just become all but impossible. But I'd love to hear your thoughts on all this. Do let me know in the comments. Please subscribe here to my channel, follow me on Instagram and Twitter, and if you want to support the channel even more, go to my Patreon page, patreon.com/David Bruce. Thanks so much for watching, and I'll see you next time.